Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Welcome to our Curious Amalgam. I'm Alicia Downey, and the title of today's episode is What Does Monopoly Really Mean? A conversation with Barry Hawk, author of Monopoly in America. These days, the debate about the role of government in regulating monopolies is getting more heated by the day. Believe it or not, the intersection of antitrust law and political science is a hot topic. Now throw more than 400 years of American history into the mix, and an already complicated subject becomes even more complicated in ways that might surprise many of our listeners. To discover what monopoly really means and what it really meant at various times in American history, we're talking today with Barry Hawk, lawyer, law professor, historian, and the author of the recently published Monopoly in America. My co-host today is Matt Reynolds. Hi, Matt.
Hi, Alicia.
Barry, welcome to our Curious Amalgam.
Well, thank you for having me, and thank you for this section. It's nice to be back with old friends.
In the time we have, we can't possibly do justice to the full breadth of your career, so I'll call out a few highlights for our listeners. Barry was previously a partner and head of the EU and international antitrust practice at Skadden through 2009. He's a longtime professor of antitrust and competition topics at Fordham Law, and for many, many years was the director of the famous Fordham Competition Law Institute. He's also the author of multiple books, including Law and Commerce in Pre-Industrial Societies, Antitrust and Competition Laws, and now his latest, Monopoly in America. Matt, we have a lot of questions for Barry. How would you like to kick off the conversation?
Well, before we start talking about Barry's latest publication, I did want to speak with you, Barry, a bit about your long history as an author, and an author in particular of books. Looking at your bio on the Fordham Law website, I saw there was something like 7 books in total that you've written or edited over the years. Wanted to ask you a little bit about how you got into the business of writing books. A lot of us write client updates or short articles or maybe even law review articles, but books are another beast entirely. So if you could share with us how you got into writing those longer volumes, that'd be very interesting.
Well, my writing of books, anyway, was 2 stages. I taught for about little over 20 years, and then I went and practiced with Skadden for a little over 20 years, right? During that period, the books, I was an antitrust lawyer and professor, so I wrote books on antitrust law. History was a minor component, but I've always liked history, so maybe I'd have an introductory chapter or something. Of history. So it was my books during those 40 years were, typical, not typical, all right, they were books for antitrust practitioners, policymakers on antitrust law and economics, right? Now, the history component was relevant to what I was doing, particularly practice in retrospect, because for the EU work, or ECEU work, it really helped to know their history. Helped in the sense of dealing with the commission regulators, because you had a better idea. Well, if you knew some history, if you know how they got to their position, say, of vertical restraints in the 80s, you were in a better position to understand why they were taking those positions. And understanding what a regulator wants is very important for clients. So indirectly, it wasn't my purpose of writing the books. I was writing books for practitioners, essentially, with a history component, but the history ended up being relevant also to the practice. The second phase was after I leave Skadden, when I retire, so for the last 12 years or so. Now, retirement, I still work 7 days a week, right? It's just the retirement means I don't get paid anymore, right?
That's quite a retirement.
Well, I don't, so I don't, retirement's sort of a nasty word for me, right? But then what I decided to do is I've always loved history, so I started reading books that were histories of things. And I began writing histories, or I wrote a history of antitrust law, competition law. That book was, there was a chapter on the United States, but the chapter was on the Sherman Act forward. So I had a chapter on everything in the world back to the Mesopotamians that you might call competition law up to 1890, then the U.S., then the EU, right? So that came out 2 years ago or so. So I decided, well, maybe I should write a book on the history of U.S. antitrust law in quotes before 1890. And when I started, I thought I was going to do everything. Well, essentially, monopolies, mergers, and cartels, right? Well, yeah, as I expected, I've discovered in a couple of days there wasn't any merger law, right, at all before 1890, before the Sherman Act. And then I found, a little bit to my surprise, I mean, I knew Justice Breyer, Senator Klobuchar, everybody goes on about monopolies, but I found that there was a serious anti-monopoly sentiment in the United States starting in 1600, starting with the Virginia settlements. Okay. So then I decided, cut through all this, I think I'll just talk about monopoly because I was finding much more about monopoly and forget about cartels. So that got me into the sort of the present writing. And I guess the positive reasons was the history was I like history. I think history provides, from a practical level, it provides a good perspective to practice and understand what's going on. And it certainly helps with creative lawyering. We go into that. I mean, it can really help you in a very, very concrete way if you know some history.
In fact, could just interrupt for two seconds,
Sure,
Barry. So
then I'll
it sounds it sounds to me as if this book, Monopoly in America, seems to have grown out of a lot of work you were doing with history and legal history in the area of antitrust, in the area of commerce generally. Was the book itself, though, something that was the topic inspired by all of the more recent discussion about monopoly? Antitrust kind of became a hot topic within the last 18 months after the change of administration. Was your book in the works before that? And did it come up in parallel, or do you see it as a response to that?
Parallel. I mean, I'd like to say it's certainly all the recent debate, right? The debate. I mean, all the excitement about antitrust and monopolies, large firms. That kept me motivated. But no, I mean, so that was certainly a factor. Okay, I mean, I know what's going on, follow, right? But it started actually. No, I saw a hole in my research in a way, right? Gee, I never said anything about what happened in the United States before 1890. Let's look at that. Okay, and as I said, I was going to include cartel. We're going to do everything, right? But I ended up, no, I'll just do monopoly. So it was more in parallel, but it certainly motivated me, no question. And I didn't have an agenda. I mean, I didn't know what I was going to find. As I said, I was surprised at the anti-monopoly sentiment. Key thing is very different concepts of monopoly. So, I mean, as you get people talking about, well, Thomas Jefferson didn't like this and all that, right? Well, yeah, but he wasn't talking about private firm monopolies, right? Who have successfully, for good or bad, they have successfully gotten a large percentage of the market, blah, blah, blah. So, yeah, so what I was doing, I was interested in initially to sort of fill a gap in my own knowledge, but I was also motivated by what was going on today.
No, that's fantastic. A little bit of a spoiler alert here for folks, for readers of Barry's book. One of the concepts that he explores in that book is these three different competing concepts of monopoly that have developed over the course of U.S. history. I was really taken by, of course, the third being sort of the both Aristotelian and modern sense of a single seller of goods, the sort of private monopoly that we all focus on in our day-to-day work as antitrust lawyers. I was, however, really fascinated by the other two conceptions that you talk about in your book, and I was hoping we could talk about those a little bit. Just to give you an overview, the first is really the sort of private hoarding, price gouging kind of concept of monopoly from, I guess, the colonial period in particular. And also, I guess, in parallel with that and moving on into the 19th century, you have the sort of government kingmaker, picking winners and losers kind of concept, the royal charter or its analog, in a non-monarchy-based system. So if you could talk a little bit about those two conceptions. I think the third, the Aristotelian, single seller of goods concept, that will be familiar to most of us listening to this podcast. The other two, though, are I think where there really is some interesting discussion to be had.
Yeah, that's interesting, Matt. Yeah, and this surprised me too. I mean, I'm a modern antitrust lawyer, right? When you talk, there's three very, I don't know, they were competing, but very different concepts of monopoly. When people would complain about monopoly and monopolizers was almost used more than monopoly, right? Which says something too. You start thinking of conspiracy theories, right? So the predominant concept from 1600, from the early settlements until the Civil War, until the modern period, was monopoly. The complaint was government grants of a monopoly or exclusive trading privileges. Okay, and that was in the initial settlements. Virginia, it was a joint venture in a way, and you had to raise money for these settlements, and you induced the investors by saying, well, the settlement company, which was a joint stock company, would get exclusive trading privileges. And right from the beginning, people screamed about that. Say, no, we don't want it. We want to trade too. So that was that concern about. And of course, that's the Boston Tea Party, which was about, well, it was the only thing it was about, but it was one thing it was about, was the exclusive trading privileges / monopoly of the East India Company over tea. Okay. And then it continues into the antebellum period. I mean, probably the biggest quote competition or monopoly case wasn't a case. It was totally political, and that was Jackson's War on the Second Bank of the United States, which was a federally created sort of a central bank, and it had many of the things that today's central bank does, and Jackson killed it, saying it was a monopoly. That concept of a government grant of exclusive trading privileges pretty much has disappeared in the modern period with the beginning of the Sherman Act, right? Because one, the concern was now the concern shifts from government monopoly or even private firms that are blessed by government monopoly to purely private firms. And on the government monopoly side, you had the concern is either disappeared or largely attenuated because the different reasons. One is economics. You had a theory of economic theories of natural monopoly. Say, well, some monopoly privileges are good. You regulate them. Another was a related reason for the attenuation of the concern. We don't care so much about them anymore, right? Is the sort of popular and political acceptance of economic regulation, government regulation. And that's reflected in the courts when you see this. And it's a surprise to me, since I haven't read anything, but I've been reading constitutional law cases since I was in law school 100 years ago, right? Was courts began deferring to all kinds of economic regulation that before the Civil War was that's a monopoly. You're granting monopoly privileges. And so, well, this is a proper exercise of police powers. So today you don't. And when you look at the Sherman Act does nothing, almost nothing, effectively about government grants monopoly privileges. Right, Parker v. Brown. All this. It's the whole rationale is federalism permits the states to act anti-competitively. All right, I'm not judging that, but I mean, if you were an antebellum or a colonial American, you'd be shocked. You say, "My God, we federalism. The concept of federalism is now overriding our abhorrence of government monopoly privileges." Well, that's what's happened. So we don't worry very much about, and the law worries almost not at all about government grants monopoly, right? The second, you call it's nice. I like your term, price gouging. You had a whole, but this goes way back. I mean, this is wonderful things of food riots in Europe. The way to think about this second concept of monopoly is a scenario. There's a drought, a famine, a war. Okay, some kind of military conflict, a war, right? And the price of grain goes up, and the price of bread goes up, and you cannot exaggerate the importance of the price of grain in pre-industrial societies. And when the price of grain suddenly went up, you had food riots. Okay, people screaming, yelling about the price of grains going up. And one scream was the monopolizers are doing it. There's some, what were they doing? They weren't. It wasn't really agreements to fix prices in a modern antitrust sense, a price fixing. No, it was sort of, they were hoarding, they were forestalling. They would go to the farmer. The idea was the farmers would sell the grain on a Thursday morning at the village market. But some people would go, these horrible middlemen would go to the farmer directly and buy the grain and then not resell it immediately, et cetera. So it was a group of ill-defined practices that today we would not have nothing to do with monopoly. I mean, there was no requirement of market power or anything. But all these hoarding, speculation, forestalling, price agreements, that was pretty rare. They were all something that people believed these, quote, monopolizers were doing. So they use the word monopolizer or monopoly, right? That probably hit its high point in the United States during the Revolutionary War. Why? Because you had inflation. So it wasn't famines, it was inflation, right? Inflation raised prices, right? Does this all sound familiar, right? COVID, right? And then you had food riots. I mean, great stuff. I mean, not just riots, but, there are a lot of examples of this. Great examples. Philadelphia, they had committees of safety set up. That's what they called them, right? Like this is 15 years before the French Revolution. And people would go in and they would just go into stores and take goods and say, you will sell the goods at X. All right. Oh, we'll take your goods. And they take the goods. Then you'd have, let's say, the more sensible people would say, whoa, this is, we need some law and order here. We have laws to deal with this, these forestalling laws. So even there, you see this tension between populist demands for action, including violent action, and let's say the legal community. That's maybe not the best way of putting it, or the law and order community, how you want to put it. Or if you're cynical, the wealthy people saying, no, that's we have a rule of law here, and we have to we have to use laws, and the laws. Primary laws, there weren't any cartel laws, real. There were some, but the primary law was forestalling laws. Interestingly, to modern days, there's tremendous evidence of people, of riots and people and violent action, people demanding action and taking action with respect to these price gouging practices. There is far less evidence of cases of enforcement of these laws. There's some, all right? So sort of you're, what's happening today? Well, okay, these economic theory comes along and says these forestalling laws is crazy. They're forestalling is a good thing. Middlemen are doing a good thing. They're redistributing goods. So economic theory pretty much in the 19th century begins to make disappear, if that's a word, these forestalling laws and this concept of price gouging. We have echoes of it today, right? I mean, the government pours in trillions of dollars for COVID. You have inflation. And what ordinarily happens here in the United States? Well, that means the price of gasoline is going up. So you have congressional investigations, demand for actions against the oil companies. Now, the only difference is there's not as much violence today against the oil companies, and people don't call the oil, well, sometimes they'll even call them monopolies too. So that would be sort of the modern, gentler example.
Well, let me just ask you though. There have been some very ungentle proposals by self-proclaimed anti-monopolists. If they see a company, they feel it's too big, the call is break it up. Is that not sort of a form of violent protest?
No, well, not my idea of violence. No, I mean,
not physical violence. Well, it's true.
Violence is always physical to me, so I don't have it. Yeah. Well, no, I in a sense, it's interesting. You make a very interesting point. The demand is in a way more serious for the firm than these earlier demands. But these earlier demands were you had. Well, for these price gouging conspiracy, these monopolizers, right? They weren't large firms. In fact, it was very unclear who they were, right? For the government grants monopoly, you had a remedy there, and it was a political remedy more than a legal remedy. You went to your legislature, or you tried to persuade the Privy Council to eliminate or repeal the exclusive trading privileges. So that was always, there wasn't so much for street action, or there was some violence, right? But to me, we're living in a far gentler world. I mean, yes, the price of gasoline goes up, and then there's speeches and Congress and the FTC, and so this is all the legal system. The colonial term would be, I get my neighbors and we go down to the local gas station and we go in there and say, you're charging $4.39 a gallon. No, you're not. You're charging $3.59 a gallon, or we're burning down your gas station.
Yeah. Okay. So we haven't devolved completely into vigilante economic justice yet.
I will say, though, I found it funny in your book, the examples you cite, particularly in the Revolutionary period. I found it interesting that the response, even when there was sort of a riot, was not, we're going to come in and take the goods. It was, we're going to come in and say, you need to only charge us X for the goods, which I will say I thought was a pretty moderate response compared to what the alternatives could have been. I'm sure there were more extreme examples, but I found that to be interesting.
Yeah, it is. Well, yeah, because the words were more violent. It's also you always at the same time, and the Boston Tea Party is an example of this. You have this violence, but you always have another group of the population, and if you don't like this, and they're wealthy, they're the elites. I mean, you describe them different way, but they're the people who are saying, "Gee, wait a second, we have rules, social rules with what we call law, and we should be using that." And once you get into the courts, and this is in a way what's happening in the modern period, in the Sherman Act, we adopt a law enforcement model. Well, that means the courts are involved. That means that the Congress made the decision that ultimately the interpretation of the law, and there's very, very, very vague laws. I mean, and all this, the legislative history is all not. It's just extremely broad. Congress passes the Sherman Act and sends the whole responsibility of the interpretation to the courts. I mean, and they do that in a lot of areas, right? So they did it with antitrust, right? Well, once you get in the courts, and the courts have their own, I'll call them judicial process concerns. We want predictable rules. We want legal certainty. We have due process concerns. We want to have administrable legal rules. That's going to happen, and that tends to make it harder to prove a case, whatever your case is, right? And therefore, in a way, if you pass a law wanting really tough enforcement, as some people did in 1890, as people do in other areas of the law, criminal law, some of the earlier forestalling and regrading laws in the colonial period, you get a weakening of what you thought you were going to get. Why? Because the courts get involved. That's, in a way, describes what's happened under the Sherman Act in the last 50 years. And I haven't used the word Chicago School here. You can describe what's going on without talking about economic policy and everything.
I think journalists, lawyers, judges, policymakers, they should all be able to draw something from the book. And the fact that you do cover such a wide range of topics. And I do want to point out to listeners, I took a few minutes to leaf through the bibliography at the end of the book. It is page after page and a fascinating collection of books and primary source materials that you read. Were there any particular source materials that you worked into the book that you believe nobody else has drawn on before?
There's no single piece of originality in the sense of sources. But what this book does, and I was saying, I use very different sources. I was reading, like in the colonial period, I was reading histories of, say, the state of New York, the Virginia settlement. Those books have, if it was a 500-page book, there were maybe 3 or 4 pages on what I was interested in. So people, certainly not economists, but antitrust people in the antitrust community would be unaware of those books because the books really have very little to do with competition law or monopoly. So that was an interesting thing. Okay, and the other extreme would be books on economic treatises on natural monopoly theory. Okay, so it was the Catholicity of the readings.
Well, it certainly comes through in the book, and as I said, the bibliography alone would make a great reading list for anybody interested in these topics. Now, we're going to have to switch gears as our time is almost up, and we want to ask you something we've asked just about every guest who comes onto our Curious Amalgam. Tell us something interesting about yourself that's outside of your vast professional career.
When I was a junior in college, I spent a year in Paris. I then ended up that introduced me to an international world and more interesting in a way to other ways, other cultures, other societies. It's and when it was, they say travel is broadening. It's the best education you can have because it opens you up to different ways. Other people see things differently from you. They have different solutions to the same problems. And I ended up emphasizing international work in my professional practice.
You were an American in Paris.
I was an
That's
American
great.
in Paris.
Okay, now for the final segment of the show, we're going to play a little game we call The Curious Hat.
And now it's time for the Curious Hat.
All there is to this game is we will select a random question from a virtual hat. This is a surprise question you have not heard before, so take it away, Matt.
All right, and your Curious Hat question today is: how would you spend your perfect weekend?
With my wife at my side, I would be editing drafts that I had written while the Eagles won a football game.
Any favorite snacks to go with it?
Popcorn.
All right. Well, thank you, Barry Hawk. You've been a wonderful guest. I do hope people will check out your book, Monopoly in America. Thanks to Matt as well, and thanks to everybody listening.
Thank you for listening to this week's episode of our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.